The Supreme Court has issued a 7-2 emergency decision that is already shaking the foundations of federal and state authority. Many in the political establishment, mainstream media, and federal bureaucracy are struggling to frame it, downplay it, or ensure its full significance remains hidden. Yet this ruling fundamentally alters how power is exercised in the United States. This decision addresses the balance between federal authority and state sovereignty. It clarifies which branch of government truly holds the reins and represents a long-awaited constitutional correction that has been building for years. The emergency order targets a critical legal doctrine, the scope of injunctive relief. For decades, nationwide injunctions became tools of political advantage rather than genuine legal remedies. When one side in Congress failed to achieve its legislative goals, it would seek a sympathetic federal judge to block an entire law or policy across all 50 states. This single judge, in one location, could halt actions affecting hundreds of millions of Americans. The Supreme Court has now declared this practice unconstitutional. The court's 7-2 decision establishes that injunctions must protect only the plaintiffs who brought the lawsuit, not the entire nation. The lower courts have overstepped by issuing sweeping blocks that turn judicial orders into nationwide policy. This is a profound change in the operation of the legal system. Practically, this affects major political disputes over the past 20 years. Immigration enforcement, environmental regulations, gun control, election rules, and vaccine mandates all often relied on nationwide injunctions. That shortcut has now been eliminated by the highest court in the land. States challenged federal overreach through the courts, arguing that emergency powers, executive orders, and federal agency actions bypassed Congress and state legislatures. Rather than addressing these claims, lower courts issued nationwide injunctions against state laws, effectively imposing federal control. The Supreme Court acted swiftly because this was not a single error but a systemic pattern of judicial overreach. Earlier signals, including the decision in Labrador v. Poe, limited lower court authority, but the practice continued. Faced with constitutional urgency, the Supreme Court issued an emergency order with 7 justices aligned, signaling an end to governing by injunction. States involved described this ruling as a victory for federalism, affirming that state laws and democratic processes cannot be frozen by a single district court judge prioritizing national outcomes. Justice Neil Gorsuch, in a concurring opinion, emphasized that courts issuing broad nationwide injunctions act as unelected legislators. He called for a return to traditional limits of equitable relief, reinforcing that courts must serve as independent checks, not policymakers. Justice Neil Gorsuch argued that courts must return to the long-standing rule that judicial remedies should match the actual harm suffered by the parties involved in a case. If one person is harmed, a judge does not gain authority to prohibit conduct affecting 300 million people. That crosses the line from justice into policymaking. And policymaking belongs to elected institutions, not federal courtrooms. His words reflected genuine frustration over what he believes has happened to the separation of powers in the United States. Through this ruling, he placed that concern firmly into the legal record in language future courts will have to confront directly. Justice Sonia Sotomayor, one of the 2 dissenters, raised a different concern. She warned that limiting nationwide injunctions may create disorder. If relief applies only to specific plaintiffs, laws could remain active in some states while blocked in others. Certain Americans would receive protection from court rulings, while others would not, depending entirely on whether they were involved in the lawsuit itself. That creates uneven enforcement, conflicting legal systems, and rights that vary depending on location. The consequences are serious, yet the majority remained unconvinced. Their position was that allowing one judge to halt national policy for the entire country creates another form of inequality. In that system, national outcomes depend on which court receives the filing and which judge is randomly assigned. For years, powerful interest groups used that strategy aggressively, pairing creative legal arguments with favorable jurisdictions. The Supreme Court has now declared that practice must stop. If Congress or state legislatures must now build more consistent legal frameworks themselves, the majority believes that is exactly how the constitutional system is supposed to function. The effects of this ruling will move quickly beyond legal journals and academic debates. They will directly shape daily life, local communities, state governments, and national policy. Immigration is one of the clearest examples. Republican and Democratic administrations alike fought immigration battles through federal courts, often relying on nationwide injunctions to suspend opposing policies. Travel bans during the Trump administration faced nationwide blocks. Immigration enforcement priorities during the Biden era were also stopped through nationwide injunctions. Under the Supreme Court's new framework, that legal strategy becomes much harder to use. A single lawsuit filed in one state can no longer freeze another state's entire immigration enforcement system. Gun policy faces immediate consequences as well. Several states enacted major firearm regulations in recent years, including expanded background checks, assault weapons restrictions, and red flag laws. Many of those measures were challenged in federal court and halted nationwide through broad injunctions. That pattern has now changed. States enforcing gun legislation will have more opportunity to keep those laws active while legal disputes move through the courts. Election law may be affected even more dramatically. Voting rights cases, voter identification requirements, absentee ballot disputes, and redistricting battles repeatedly relied on nationwide injunctions. The Supreme Court's ruling now makes it far more difficult for a single lawsuit to suspend election rules across the nation. Election policy battles will increasingly shift back towards state legislatures and Congress through the democratic process, instead of being decided by whichever side reaches a favorable federal judge first. Environmental regulation is another major battleground transformed by this decision. The Clean Power Plan, methane restrictions, water regulations, and endangered species protections were all blocked at different times through nationwide injunctions issued by district court judges. That legal weapon is now far less available. The struggle over environmental policy is moving away from federal courtrooms and back toward legislatures. Groups that depended on courts to preserve environmental regulations Congress would not pass have now lost a major strategy. Political fallout began. Immediately after publication of the ruling, the White House and the Department of Justice released cautious statements saying they were reviewing the order. They neither praised nor condemned it. That wording reflected institutions trying to manage the consequences without publicly admitting the scale of the setback. Inside the Department of Justice, officials reportedly described the ruling as a legal earthquake. For an agency that spent years using federal courts as tools of policy enforcement, the decision represents a major disruption. Meanwhile, state attorneys general moved rapidly. Within hours, multiple states submitted supplemental legal briefs in ongoing cases, citing the Supreme Court's decision as direct support against federal overreach. Legal teams across the states had clearly anticipated a ruling of this kind and acted immediately once it arrived. Those filings argue that the Supreme Court had reaffirmed a principle the states had defended for years. States possess the authority to protect their sovereignty without being subjected to sweeping injunctions imposed by federal judges, advancing policy preferences over democratic processes. The political reality behind this decision reaches beyond one party or ideology. In the current moment, many of the states energized by the ruling are red states challenging Biden-era federal actions. But the same dynamic reverses depending on who controls the White House. When Democrats hold executive power, Republican attorneys general often seek nationwide injunctions against progressive federal policies. When Republicans hold power, Democratic attorneys general use the same strategy against conservative policies. Both parties participated in the system. Both benefited from it, and both accused the judiciary of overreach only when the opposing side gained the advantage. The Supreme Court has now instructed both sides to stop. If political leaders want to shape national policy, they must do it through elections. Legislation must be passed through the democratic process the Constitution actually set up. You cannot create a nationwide policy simply by filing a lawsuit in the right city with a sympathetic judge. That era is officially over. So what happens now? What does the future hold for American law, politics, and the ordinary citizen trying to understand the impact on daily life? First, recognize that this was an emergency ruling. It is not a full final opinion. The case will return to lower courts, which must now apply this new, narrower framework to the specific disputes before them. Every lower court judge knows the Supreme Court is watching. Issuing a broad nationwide injunction without strong justification will result in quick reversal. The federal government will push back. It will seek cases arguing that the national interest is so compelling and the constitutional stakes so high that broader relief is warranted even under the new standard. There will be test cases, appeals, and circuit court splits where different appellate courts interpret the framework differently. Those splits will eventually bring the Supreme Court back to issue a full merits decision. This is the beginning of a long legal recalibration, not the end of the struggle. What will not return to the old system is the public, formal declaration by a 7-2 supermajority that using nationwide injunctions as a political shortcut is constitutionally illegitimate. That pronouncement carries enormous weight. It changes how lawyers advise clients, how advocates structure strategies, how federal agencies calculate risk when issuing rules or challenging state laws, and how states consider legal exposure when passing controversial legislation. The entire framework of American legal strategy has shifted. A deeper implication must be stated plainly. For decades, both parties quietly allowed the federal judiciary to amass power it was never meant to hold because it was convenient. You could achieve national policy goals without winning Congress or state legislatures. You could bypass the work of building democratic coalitions and persuading citizens simply by finding the right judge. The Supreme Court has now closed that door. American democracy is being forced to function like an actual democracy. To achieve change, you must win elections, pass laws, and govern. Courts cannot substitute for political legitimacy. This system is harder, messier, and will produce results that frustrate people across every debate, but it is what the Constitution created. 7 justices used one of their most powerful tools, an emergency ruling, to push the country back toward it. This is not just a legal dispute. It is not simply a technical ruling on injunction scope. The Supreme Court drew a fundamental structural line about how power should flow in the United States. For years, lower courts grew comfortable acting as policymakers, issuing orders that affected the entire nation and letting the judiciary be manipulated by whoever had the best lawyers in the friendliest jurisdictions. 7 of 9 justices said, "Enough is enough." The remarkable aspect of this ruling is the breadth of the coalition. 7 justices across ideological lines agreed. This is not a partisan split. It is a cross-ideological consensus that sweeping nationwide injunctions used as political weapons have gone too far and caused real harm to the constitutional order. 7 justices agreeing on something this significant is a moment to take seriously, no matter your politics. This is a constitutional moment, not a team sport. The ripple effects will last years, possibly generations. Law schools will teach this case. Constitutional law professors will create modules around it. Federal judges will cite it in injunction disputes for the foreseeable future. Legal strategists and advocacy organizations, government agencies, and public interest law firms are rewriting their playbooks because the old approach will no longer work. The Supreme Court has spoken with clarity and force, leaving little room for reinterpretation. The defining question now is whether political branches will respond responsibly. Will Congress develop clearer, more consistent frameworks so the absence of nationwide injunctions does not create chaos? Will state legislatures respect constitutional limits in their lawmaking? Will federal agencies act more disciplined and constitutionally grounded in issuing rules and enforcement actions? Or will new shortcuts and workarounds be sought, despite the court's warning? The Supreme Court can draw a line, but it cannot enforce respect for it. That duty falls to voters, citizens, and the people who elect politicians and appoint judges. Self-government is intended to be hard. Democracy requires effort. You cannot delegate your political failures to a federal judge and call it justice. This 72 emergency ruling is a historic turning point. Whether it becomes a true correction or just a temporary speed bump depends entirely on what happens next in legislatures, elections, courtrooms, and the public awareness of a country that needs to remember the Constitution. This is the full weight of the moment. This is an institutional shift that will not vanish amidst daily outrage cycles, partisan shouting matches, or social media storms. It matters now. It will matter in 5 years. It will matter in 20.